Good evening to you all. I will be taking you through basically the entire scheme of the Civil Procedure Code, the requisite sections, the requisite orders linked to those specific sections. When are these sections are to be put to use? In what way these orders, which are linked to these sections, will come to your aid, and things like that. Let me just start by segregating and outlining the difference between the sections and the orders. Like why there are certain sections and why there are certain orders, and what's the essential difference between the substance of both these things. Uh, so the sections, the essential sections which have been outlined in the CPC, primarily give you an outline as to what and how your relief may lie, or what is the procedure, or what is the broad outline of the procedure that you need to follow when you're claiming something or exercising your right to get some relief from the court. The orders that are linked to these specific sections outline a very detailed procedure as to how exactly you need to claim these rights. For example, Section 96 of CRPC, it's okay. You don't need to scroll. It's okay. I'll just explain and we'll just come to that section as and when we come. Yeah. For example, Section 96 of the CPC tells you that there lies an appeal against any order which has been passed in the original jurisdiction, basically what you call your first appeal under CPC. Now, Section 96 would stop there. This has to be linked to Order 41 of the first schedule of CPC. Now, Order 41, if you see, of the first schedule of CPC clearly outline as to what would be the format of this appeal, what all things that you need to mention. For example, it clearly states that there has to be a memorandum of appeal, which has to be in a specific format. Plaintiffs have to be mentioned, defendants have to be mentioned, the grounds that you're quoting for your first appeal have to be mentioned. So all these things, the nuances that will go on when you raise a first appeal are mentioned in the order, in this case, Order 41. So basically, it makes your life a little easy. And when you're claiming your first appeal by way of Section 96, Order 41 will tell you exactly in what format you need to file that first appeal and what are the essentials that needs to go in when you draft that first appeal or when you file that first appeal. So this is basically the delineation between two parts of the CPC, the orders and the sections. Now, we'll start with the brief scheme of the CPC in general. We will be, today, we'll be talking about the broad sections, touching upon these sections, giving you a slight overview. We will not be dwelling into the details, which we'll go as and when we take these sections individually. But just to give you an idea as to what awaits and what how vast and how detailed the Code of Civil Procedure is. We'll start with the basic sections. Section 2, for example. Section 2 in the Code of Civil Procedure, and for that matter in any act or any statute that is passed, as a matter of rule, contains the definitions of various things or terms which might be relevant for that specific statute or the matters to be decided in that specific statute. Similarly, the Section 2 of your Code of Civil Procedure outlines the definitions of various things or various terms that might be relevant for the proper adjudication of disputes of civil nature. Now, this has a very specific purpose. The definitions, of course, add a lot more clarity to your general scheme of the act, because it tells the court, it becomes very easy for the court to analyze, okay, this, if something is being raised, then there's a clear definition, this is what we need to refer to, and this is how we will take this thing to be. Because when you're dealing with law, when you're dealing with legal terms, as you all know, there might be multiple interpretations which could be taken by the courts. And of course, the courts have the power to interpret terms and, of course, laws as well. So, in order to make things easy, more coherent, and more logical, certain basic definitions which are envisaged by the framers of any statute are given under Section 2. Now, the important thing to note, an interesting thing also, is that when you look at Section 2 of any act, the definitions are arranged in alphabetical order. So the terms which are defined under Section 2 are very clearly arranged in an alphabetical order when you look at Section 2. Again, definitions can be inclusive. It can mean, for example, the code, the definition of code in your civil procedure code is an inclusive definition. Inclusive definitions are basically the definitions which give the court a very wide ambit. So it will state that the present so and so thing includes so and so thing. These definitions, the inclusive definitions, are usually the ones which are very, very widely interpreted, very liberally interpreted by the courts. Similarly, you have exhaustive definitions, which start by the terms that so and so thing means so and so thing. So it's very clear, courts usually restrict themselves, and generally a strict interpretation is followed when there is a exhaustive definition or an exclusive definition which is given in the court for a specific term. Now, moving on to the next important section, Section 6, which outlines the pecuniary jurisdiction of the courts. Now, Section 6 has to be read in conjunction with Section 9. Section 9 of your code states that courts are empowered to try certain suits unless they are barred by certain sections contained herein. Now, these certain sections contained herein, which bars the court in certain cases to try some specific suit, are as follows, one of which is Section 6. Now, Section 6 bars the court to try a suit for which it does not have the requisite pecuniary jurisdiction. For example, in the district courts of Delhi, they do not have a pecuniary jurisdiction to try a case over and above 2 crores. So, by way of Section 6, the district courts are barred to try these cases which have a pecuniary jurisdiction of a higher value. Section 9, of course, comes to the aid of the court in conjunction with Section 6. Other sections, requisite sections in conjunction with Section 9 are Section 10, 11, 12, which also offer some sort of bars to the court while they are hearing cases. Section 10 deals with your matters which are sub judice before other courts, matters having the same cause of action, the same title, the same parties which are being heard by any other court having competent jurisdiction, then that particular court is barred. Section 11 is a similar section which is called res judicata. It deals with certain cases which have already been heard and decided, which are not pending, but decided by the courts having competent jurisdiction and same cause of action. Similarly, Section 12. Section 12 bars any further suit to be instituted in case a cause of action has been decided, or in case a plaintiff is somewhat precluded from filing a further suit. Now, this preclusion can be by way of the local high court rules, can be by way of any other law, any special law which might override Code of Civil Procedure, as it's a general law, and things like that. So that is to outline that what cases can be taken up by the courts, the specific circumstances wherein the courts might be barred to take up some specific cases, so on and so forth. Okay, moving on. Next specific sections, before we come to place of suing, two sections which I would like to touch upon are cases relating to foreign judgments. Any judgment which has been passed by a competent court of a foreign judicature, which in what cases will it be applicable in the courts of India, in which cases these judgments will not be applicable. Now, when you look at Section 13, it starts by stating that a foreign judgment shall be conclusive as to any matter thereby directly adjudicated between the same. So basically, there has to be a presumption that this judgment will be taken to be conclusive. Now, the same section also offers certain exceptions in which, in those specific cases wherein these specific judgments which not be held to be conclusive. They are very clearly outlined. It might be a case that that foreign judgment may be obtained by way of fraud. It might be opposed to natural justice. It might not be given on the merits of the case. It might be pronounced by a court which does not have the competent jurisdiction, so on and so forth. Generally speaking, coming to section 14, these foreign judgments are presumed to be passed by a court of competent jurisdiction unless it's being specifically challenged and a certified copy has been uh, produced thereof. So whenever a foreign jurisdiction judgment is taken up or referred to by a party, there is a presumption that this specific judgment was passed by a competent court, a court having competent jurisdiction to pass that specific judgment, unless this presumption is displaced by the opposite party by raising an objection and proving that objection. This is as far as the regulation of foreign judgments and their uh, usage. Then coming to a very important set of sections in your CPC, which govern your jurisdictions. As we had explained in the previous session, which I had taken when I was referring to the drafts, there are three specific jurisdictions which are to be referred to and which have to be clearly stated when you file a pleading in any court of law on the civil side, whether it's a district court, whether it's a high court. You need to clearly you need to specifically state that this subject matter which you're raising, this court has competence to try this subject matter. The pecuniary jurisdiction if considered, this court has the requisite pecuniary jurisdiction. In case the property it's in the nature of an immovable property, then specific court has the requisite territorial jurisdiction to address this issue, so on and so forth. So from where these specific pleadings have to emanate are what your sections 15 to 20 essentially talks about. Now, section 15 specifically talks about the courts where you can initiate your suits. Specific thing to note is, let's say it's an immovable property. So, of course, by way of logic, where that immovable property is ordinarily situated, that competent court might and should be the ordinary court wherein this issue can be raised. Section 15 also gives you certain leeway to file this specific suit in certain other jurisdictions, but there are certain regulations, of course. Now, these regulations or conditions are that, let's say there's a person against whom your claim lies, and that person is residing voluntarily in a different jurisdiction, or that person is carrying on his business in a different jurisdiction, or that person is working for gain in a different jurisdiction. So, in these specific cases, your claim against that person can also be instituted in the requisite court having jurisdiction over those specific scenarios. So let's say if the property is situated in Delhi and the person is residing in somewhere in Uttar Pradesh and he's working for gain there, you can very well institute a suit making your jurisdiction under Section 15 in that specific district of Uttar Pradesh. Section 16 specifically talks about, again, where the subject matter is situated, which I have just explained. Section 17 talks about the immovable properties in the case where such immovable property might be situated in the jurisdiction of two different courts. Let's say there might be 10 different properties which is owned by a single person against your claim lies. And some of the properties are in Delhi, some of the properties are in Faridabad, some of the properties are in Ghaziabad. So by way of Section 17, your suit may lie in any of these three different jurisdictions. Now, Section 18 talks about where the local limits of jurisdiction are uncertain. Now, when these local limits of jurisdiction are uncertain, uh, first thing that you need to prove is that there is an uncertainty. If you're able to establish that uncertainty, and if the court is satisfied, then any of these two or more courts wherein there is an uncertainty can address the issue. Section 19 essentially talks about a compensation which can be paid in case if you raise a claim before a competent court, wrongly stating that this person is, let's say, voluntarily residing there, or it's carrying out personal work for gain or things like that. So that is in the nature of costs. But of course, that costs are limited. The limitation has been specifically stated in section 19. Now, section 20. Again, other suits which have to be instituted where the defendant resides, similar claims, similar things as I have just explained in section 15 to 19. We'll take up these sections individually as and when we take up the issue of jurisdiction to go on to the details. Section 21 gives you the power to raise objections if you have any objection to the jurisdiction which has been raised by the plaintiff, and things like that. Okay, moving on. Yeah. Now, this specific sections, okay, now we are clear that where we need to file a specific suit, what are the sections that specifically govern those pleadings, and where and how these suits can be objected to, the jurisdiction issues can be raised. Now, your section 22 essentially talks about the transfer of cases. Now, this is again a natural outcome of the things I've just explained between section 15 to 19. Let's say there's an issue which has been raised on account of jurisdiction. Let's say if you raise an issue that this person is not voluntarily working for gain or residing in this specific jurisdiction, then of course there has to be a mechanism wherein the courts rightly observe that, okay, this issue has been wrongly raised, and this court does not have the competent jurisdiction. So this specific lot of sections talks about those specific cases wherein the courts have the power to transfer those cases from one court to the other, or from one jurisdiction to the other jurisdiction. Now, which court has the power to transfer this case? Where do you need to file this specific application for transfer? Is what these sections specifically talk about. Generally, just to give you a brief idea, usually the application for transferring a matter is to be raised before a court which is one level higher than the courts wherein this matter has been filed. Let's say the matter has been filed before a civil judge of junior division, then the court which has the requisite power to transfer this case will be one step above, right? In similar cases, if let's say there's a case which has been instituted by before a court of a district judge, in that specific case, the requisite high court will have the power to transfer that case from one specific district to the other specific district. Section 25 specifically talks about the powers of the Supreme Court in this specific circumstances, wherein a case has to be transferred from one high court to the other high court. There is a very specific circumstance which has to be met, which is outlined in section 25 itself. That is that you have to put up a very reasonable ground, and there has to be some end of justice which seem to be defeated before the Supreme Court allows your transfer. But as to what are the nuances and in what circumstances Supreme Court can make this order is what section 25 deals with. Okay, coming to the next lot. Now, the major thing, coming to the main suit. When you're done with your drafting and you institute a suit, Section 26 talks about the fact that every suit has to be instituted by way of a plaint. Now, what is a plaint? what are the ingredients of plaint, what all should go into the plaint, what should be the structure of that suit, what should be the specific things that you need to outline, what are the forms of pleadings that you need to plead. All of these things are explained in requisite orders, which I'll just explain and which you can see on the screen, which are sort of interlinked to your section 26. Now, section 26 is just an umbrella section. It's a two-line section which just states that your every suit shall be instituted by presentation of a plaint or in such a manner as may be prescribed, and that this plaint has to be proved by an affidavit. Now, I would take you straight to Order 1 of Schedule 1 of CPC, which talks about the parties, who all can be joined as plaintiffs, who all can be joined as defendants when you're drafting this plaint, uh, what is the format, what do you understand by misjoinder, in what case the courts have powers in case there is a misjoinder and a non-joinder. Now, misjoinder is basically a situation when you join a wrong party or a party which was not to be impleaded as a party has been impleaded. So that party can file for a misjoinder and the courts have power to remove that party from the proceedings. Similarly, non-joinder is a situation wherein a requisite party which should have been included as a necessary party has not been included. So, of course, courts have the power to include and direct the inclusion of that specific party. Then what will happen in case the suit has been filed in the name of a wrong plaintiff? Then what are the powers and what is the specific procedure which has to be followed? You have a specific rule. Then in what stage and in what manner the objections in the situations of a non-joinder or of a misjoinder can be raised. For that, you have a specific rule. So basically, this order clearly outlines and very specifically tells you that these are the things that you need to comply with. These are the powers which the court can exercise, and these are the cautions which the court has to be aware of while it is dealing with a plaint. Now, Order 2 of your CPC deals with frame of this suit, or what you can call the structure of this suit. Similar situations, every suit has to be framed. It has to have all the grounds. It has to have all the claims. Now, important thing is that when you file a suit, you need to include all the claims that you seek to establish on the basis of that specific cause of action, unless you are keeping some in abeyance by way of order to do, which we'll just come to. But as to what all things should go when you're framing and in what structure your suit should be framed is what your Order 2 tells you. Similarly, Order 4 tells you that how these suits, once they are instituted, are to be registered. There's a specific register. Nowadays, it's online, which is to be kept by all the high courts, and every suit which is instituted is registered. So the specific number of the suit that you get once the suit is registered by the registry of is the procedure which is outlined in Rule 2 of Order 4. So what I mean to say is this specific law makes it very clear and very easy and very logical, coherent for the courts, for the parties, and for the advocates to institute the proceedings. Okay, so there's no scope of confusion which is left. Now, there might be certain circumstances wherein there might be situations where certain things might be excluded from these specific, very minor situations, but yes. So in those specific situations, as we talked about in the last session, the court is assisted by the rules which are framed by the specific high courts on the civil side. Every high court has the power to frame rules. So those rules come to the aid in case there is something which is missed by these specific orders and rules. Okay. Now you have instituted your suit. Of course, I think this comes up later, but I'll just touch upon, since we are talking about the structure of your plaint, Order 6 and Order 7 of your CPC also deals with the manner in which your pleadings have to be presented. Okay, it's okay, Sanskar, I'll just brief. I don't think it's mentioned, yeah. So order 6 and order 7, while we are talking about the structure, how your pleadings should be, how clear your pleadings should be, how concise it should be, in what form you need to put up your pleadings, by what way the courts can allow an amendment to the pleadings. All of this is mentioned in order 6. Similarly, what particulars have to be entered, in what format, what other details of the plaintiffs have to be given when you're filing a plaint, in what cases the plaint can be rejected, what are the documents that have to be, and in what format the documents have to be presented when you file a plaint. All of that is given in your order 7. So these specific orders complete your lot regarding the institution of a case by way of a plaint and the format in which you draft your plaint and the form in which you present your plaint before the High Court or any other court for that matter. Okay, now we come to the next lot, which deals with the summons. Now, once the case is instituted, once the case is registered, naturally the opposite party has to be intimated. That is intimated by way of summons. Now, how these summons have to be framed, how, in what manner these summons are to be dispatched, what manner these summons are to be dispatched in case it is to be given to a to a person who's residing in foreign jurisdiction, how these summons are to be dispatched in case the summons deal with some interrogatories or these summons are for discovery of a fact which the court feels is necessary, is what this lot of sections talk about. Section 27 talks about in what way the summons are to be served. Important thing to note that the wording of section 27 is very clear that court may issue summons. Now, the thing why the court used the act says that it may be the court may issue summons is because clearly there can be situations where the court might not be inclined to issue summons, or there can be situations wherein you have served the opposite party in advance and the party is appearing on advance notice, right? So there's clearly no issue and there's clearly no motive to for the court to issue a summons. So in that cases, courts don't issue the summons for appearance of the parties and they take it forward. Now, 28 talks about when, let's say, your defendant is residing in another state and you're filing on the basis of some property which is in the jurisdiction of this state. So in that specific case, the notice or the summon goes through that specific court which has the jurisdiction over that specific area where the defendant is residing, right? So how the summon goes, clearly delineated in section 28. How foreign summons are to be served, delineated in section 29. Section 30 specifically talks about when there is a situation wherein some facts have to be discovered or some interrogatories are filed to which the courts need an answer. So in what format those summons and how and in what circumstances those summons can be issued is what your section 30 talks about. I'll just give you an example to clarify this section. Let's say, and these summons can be issued for production of documents. This summon can also be issued under section 30 for to a specific person who has possession of those documents, so on and so forth. For, let's say, a court requires certain information from the local registrar, right? Or if the court requires to have clarity on a situation of a property which has been registered in a particular area before the registrar. So court under section 30 has the power to direct the production of those specific property documents from the registrar's office. In section 30, the court also has the power, along with summoning those documents, to summon the registrar himself in person in order to prove those specific documents. Okay, so there's a dual purpose which can be fulfilled by way of section 30. Section 31 again talks about when you have to summon a witness. Section 32 talks about the penalty which can be imposed in case the person fails to comply with the summons which has been issued. Now, this lot of sections is also linked to a specific order which just give all the details that are required for issuance of the summon. Detailed procedure, which I've just explained in brief, is what is covered by Order 5. Now, moving on to the next law. Now we have filed, instituted a proceedings, the summons have been served, let's say the trial has concluded, and the judge has sat down and come and is ready to pass a judgment. Now, Code of Civil Procedure also explains in what format a judgment, on what occasion, in what manner a judgment has to be pronounced, in what manner a decree has to be formulated, in what manner a decree has to be given, or if it has to be sent to a foreign jurisdiction, in what manner it has to be sent, if it has to be sent to some jurisdiction of other high court, in what manner it can be done, things like that. Judgment sections, section 33, is uh, linked to your order 20, which tells the court as to how this judgment has to be pronounced. For example, it states that a judgment has to be pronounced in an open court. It states that a judgment has to be pronounced uh, essentially within 30 days of the matter being concluded. There might be a situation wherein there might be a delay. So in that case, there is also a cooler period which is given for another 30 days. So between 30 to 60 days is what CPC tells the court to pass a judgment. Now, this order also talks about in what format a decree has to be drawn on the basis of the judgment, in what format the decree has to come, what are the essentials of a decree. For example, it has to have a number of the suit, it has to clearly specify what reliefs are granted, it has to clearly outline as to the orders regarding costs, if any, have been made in a judgment. So very, very clearly, this lot of sections and orders explain to the court, and of course makes it clear for the parties also and the lawyers also as to what are the essentials of a judgment and what are the essentials of a decree that will be passed after a judgment has been pronounced. Now, similarly, there's a term which appears, mesne profits. Of course, court can also declare that certain mesne profits to be awarded to the person. Mesne profits are basically when the property is not in the possession of the person who has a rightful claim over it. Then these profits, which rightfully belonged to this specific person, should be given to that specific person. So we'll deal about it as and when we deal about this part in detail in the coming sessions. 35 talks about the costs of a suit. Now, these costs are basically the costs which are entailed by a party. Let's say when you have to draft your plaint, you have to spend money on photocopies, you have to file a process fee before the court, you have to file money for photocopies, you have to file a specific fee for translation of documents, things like that. So court under section 35 also has the power to determine as to which party of this specific suit will be bearing the costs. In case the costs are to be borne by the specific requisite parties, order is made to that regard. In case one specific party has to bear the entire cost, an order has to be made to that effect. Basically, whatever it is, it has to be very, very clearly specified, and CPC makes it clear. Now, costs under section 35B. 35B costs are slightly different from the costs that 35A talks about. 35B costs are by way of compensation. It's in the nature of a penalty, which the court can impose if one party is causing a deliberate delay to the case, or if it's avoiding the cause of justice and things like that. Basically, it's of the penal form, and it's different from the cost in 35A, which will deal. As you can see, Order 20A, which deals about the nuances of the costs and in what circumstances and in what cases the cost can be avoided, and what are the rules which govern the implementation of these costs. Yeah.
Advocate Rohan, we can take a 5 minutes breather whenever you want. Just let us know whenever you want that.
Okay. No issues. Okay. Now, this specific sections, lot of sections, talks about the execution of the decrees that you have just obtained by the previous lot of sections. Execution is, of course, a way to get your decree implemented. In what manner these execution proceedings are to be carried out, in what manners the orders have to be framed, which court has the power to pass the execution of a decree, where this plea may be raised, what will happen in case there is a judgment which has been passed by one specific court and the execution property or the property which has to be attached lies before or within the jurisdiction of a different court. All these situations are outlined by this lot of sections, and what procedure has to be followed by the courts in these specific cases are outlined by these specific sections. Now, section 36, application as to orders, basically it just intends to say that whatever rules, whatever orders are applicable in the context when court passes an order are also applicable in the cases wherein the court are dealing with execution proceedings. Then, of course, Section 37, which court has the power to pass a decree or execute a decree. Now, let's say a matter has been decided at the appellate level. Now, the person in whose favor the decree has come moves for execution. Section 37 tells you that the court which has the power to execute this order will be the court of the first instance. And such a plea will not be raised before the appellate court, even though you have a decision from the appellate court. This decree can be executed by the court of the first instance also. So basically, what all procedures these sections deal with, we'll deal with it in detail when we deal with this specific topic. But just to give a brief overview as to what all things are there. Moving on to the next lot, section 46, precepts. Precepts are nothing but letters of warrant which might be issued in order to aid the execution if in case the execution property in some is situated in some other jurisdiction and things like that. When section 55 gives the power to arrest and order for civil detention in case the execution proceedings and the orders in the execution proceedings are not being complied with, and things like that. Section 60 specifically talks about what are the properties that can be attached. Okay, can you just move on a little bit? Yes. Order 21. Order 21 basically deals with uh, the rules which govern the execution proceedings. These are linked to this lot of sections. It outlines what lands situated when land is situated in more than one jurisdiction, then both the courts have the jurisdiction, anyone can execute. When court desires that own decree shall be executed by another court, when there is an oral application instead of a written application, what is the procedure? For example, even an oral application, then court can order detention and execution. Let's say there are cross decrees. Let's say one person has been granted a decree of 1,000 rupees and the other person has been granted a decree of 2,000 rupees against the first person. Then in that specific circumstances, how to settle the claim, right? So what is the procedure to be followed is what these rules deal with. How to issue a process, in what cases the execution may be stayed, in what cases there can be injunctions that can be issued in case there is willful disobedience of the court's decree, uh, in what cases the attachment of properties can be made. Now, section 41 to 57, when we are just giving you a brief of execution, also talks about the properties that cannot be attached. For example, your essential items. You cannot go on to a person and attach the clothes that he's wearing. You cannot go to a person and simply attach, let's say, a customary jewelry which the person's wife is supposed to wear as a matter of custom. You cannot go walk up to an agricultural laborer and attach the only cattle that he might have, right? So there are certain essential things which might be required for the subsistence of a person. So those specific things are very well excluded from the attachment when such an attachment is to be carried out under the court orders. So what I mean to say is the code is very, very, very specific, and I must say very humane also when it talks about such attachment proceedings. Okay, moving on. Yeah. Okay. Appointment of commissions. Commissions are basically a certain group of people or a single person which might be appointed as a commissioner by the court to ascertain a matter of fact, a cause of action, any other thing which the court himself cannot physically go and examine. So, for that purpose, the court, under this specific lot of sections, has the power to appoint either a single person as a local commissioner or a body of persons or a committee of persons in the form of a commission to aid the court and to ascertain certain facts. Now, this power of court, in what circumstances to be exercised, is outlined by Section 75. Now, in what cases these commissions can be sent to a different jurisdiction has been outlined in Section 76. For example, it has to be sent through a court which has jurisdiction over that particular area. uh, Letter of request. Letter of requests are to be issued in cases wherein there is a witness which has to be examined and who is not residing in India. In that case, there is a letter of request which has to be made. Then commissions to be issued by foreign courts or for matters before foreign courts. Similar rules, which Section 75, 76, and 77, read with Order 26, outline, are applicable under Section 78 to foreign courts also, or in cases involving foreign judgments. Uh, Commissions, Order 26 talks about in detail for what purposes these commissions can be appointed to examine a witness, for local investigations, for some scientific investigation, a commission of expert members can be constituted for performance of a ministerial act. Rule 16, a very important rule which deals about the power of these commissioners. For example, these commissioners have powers to examine someone on any other issue which the court has not specifically stated them to examine in case they feel it's necessary. They also have powers to enter into any lands or buildings if they feel it's necessary for the determination of that issue at a reasonable time, of course. So things like that. So this is what you understand by commissions, how the commissions are appointed, and how the commissions, what kind of powers these commissions have. Now, this lot of sections talk about certain special cases wherein the government might be a party, wherein a suit has to be instituted either by the government or against a government or against a person is who has done an act in his official capacity. Now, what procedure do you follow in these specific circumstances is what this lot of sections talk about. For example, there's a very specific way to issue notice. There is a specific set of rules how you issue notices in these specific circumstances. There has to be a written notice, at least an advance notice of 2 months, which has to be served to the secretary to the government of India in case a suit has to be instituted against the central government. In case there is a state government against whom a suit has to be instituted, that has to be done through the requisite chief secretary and things like that. Section 82 talks about how execution of decrees in case a suit is decreed against the government has to be implemented. So, for example, there has to be a 3 months gap after issuing of the decree and before the execution proceedings can start in the cases where the central government or a public officer is a party. Order 27 deals with these specific rules to aid the specific lot of sections. One specific rule which I'll just outline, Rule 5B, which had been added later on, which basically states that in case there is a suit which is instituted against a public officer or against a government, the courts have to push and see the possibilities in case there is a possibility of an amicable settlement. If that is the case, the court can either appoint an officer, can either appoint a mediator, can either himself mediate to see that an amicable settlement is reached so that there's no need of initiating an action. So these specific set of rules under this specific order 27 uh, deals with such circumstances. Now, when suits can be filed by the aliens. Now, by aliens, I mean to state that a person who's not a citizen of India. You can refer to the, although it was a criminal proceeding, the case of Italian Marines who were, so Italy is a friendly nation, it's not an enemy nation, but those Marines were not citizens of India, but rather they were tried in India. Now, if let's say there is a civil case which has to be instituted by an alien, now aliens can be your friendly aliens, your aliens can also be persons from an enemy nation, a nation which has been declared by the central government as an enemy nation. So, what are the procedures to be followed, and in what manner such aliens can bring suits before the courts in India is what this specific dot of section talks about. For example, if it's a friendly alien, he can directly sue as if he is suing as a citizen of this country. If it's an enemy alien, then he has to have a permission from the central government before he initiates an action. Section 84 talks about when foreign states, in the capacity or through their ruler, can sue before the courts in India. So you have a specific procedure for that. And there is a very specific circumstance when this suit can be brought. What is that circumstance, and when that suit can be brought is what Section 84 talks about. Section 85 gives the power to the central government to appoint a prosecutor or a defendant on behalf of any foreign state or on behalf of a foreign ruler if the foreign ruler requests the same. Section 86, of course, the process which has to be followed in case there has to be a suit which has to be instituted against a foreign ruler by an Indian citizen. Therein, you need central government permissions and certain other modalities, which this section talks about. Okay. Uh, Interpleader suits. Now, this specific section and Order 35 deals with interpleader suit. Interpleader suits are basically your suits wherein two persons have a conflicting claim against a third person, uh, and the third person is okay to part with the property or to give the claim, but he is not sure as to whom he should be giving that specific claim. Let's say there are three people A, B, and C. Now B and C have a common cause of action against A. Now B says that he has the rightful cause. C says that he has the rightful cause. Now A in this specific circumstance has the power to file an interpleader suit to ascertain as to which of the following is the rightful person to whom he should uh, defray or to whom he should give away that rightful claim. So, this specific section and what are the modalities of the plaint in such specific circumstances, what is the procedure to be followed, what is the procedure at the instance of first hearing, things like that, what orders can be made as regard to costs, are dealt with Order 35, read with Section 88. Then we move on to the category of certain special proceedings. Section 89 talks about the cases wherein the court feels that there might be a situation wherein this claim can be sorted out of court. Now, and in this specific circumstance, under Section 89, although it's mentioned arbitration, court essentially has the power to direct the parties to refer the matter either for arbitration, it can refer for mediation, it can refer for an out-of-court settlement before a court-appointed person or a court-appointed commission, things like that. Section 91 is different from Section 89. It's also a different kind of special proceedings wherein the court expects that there can be a possibility of public nuisance. In those specific cases, courts either on its own motion or if an action is initiated by the Advocate General of a state, can pass orders regarding declarations, injunctions, or any other order to prevent such public nuisance. This is also a special circumstance which is not not a usual thing which we'll see in courts. But just to give you a brief as to these specific circumstances are dealt with. Then supplemental proceedings. Supplemental proceedings are basically also a category of special powers which the court have in case they feel that certain ends of justice are being defeated. Let's say there's a person who is not appearing despite repetitive summons, right? Let's say there's some willful disobedience. The court under Section 94 has the power either to ask this person or this person to be detained under civil prison, to attach a specific property, or the power to direct attachment of the property of this specific person, or in case this specific person can also be directed to uh, keep some of his personal property as a security for his appearance and things like that. So these are also ancillary sections which you just need to know about in case you need to resort to these in some of your cases. Uh, Section 95 basically talks about compensation which can be given in case these supplemental proceedings under Section 94 are found to be initiated under wrong presumptions, or if the court feels that these were not supposed to be initiated. So in this specific case, Section 95 gives the power to the court to grant some sort of compensation to the person who has been charged under Section 94. Okay. Now, again, to a very important set of sections which deals with your appeals. Section 96 talks about where your appeals lie from any original decrees, where this, of course, has to be read with Order 41, which I just referred to in the start. Okay. You can just right. So appeals under Section 96 is what you call your first appeal. The requisite orders relevant for the sections dealing with appeals are 41, 42, 43, 45, which you just see on your screens. 97 specifically talks about when a situation wherein there is no appeal which lies in case a court has made a preliminary decree, right? And if you do not appeal that preliminary decree as a matter of appeal, you are you're sort of precluded from disputing the correctness. Section 98 again talks about when and in what manner a decision to be given and in what manner an appeal has to be heard in case there are two or more judges. Let's say it has to be decided by the majority, or what will happen in case there is a division of opinion, what will happen if there is a division of opinion on point of law, and things like that. Section 99 talks about the fact that when a court is sitting as a court of appeal, the decree will not be reserved or modified in case there seems to be an error or irregularity which does not directly affect the merits of the case. It can be a clerical error, it can be a slight procedural error, it can be any other thing. It can be a error related to format, which an error which does not directly deal with the merits of the case, or it does not directly affect the jurisdiction of the court which was dealing with the issue. In case there is any such error, Only on the basis of that specific error, the court will not be reversing or modifying the decree which has been passed by a lower court. Now, the next lot of sections deals with your second appeals. Second appeals, of course, are appeals which lie from the decision of your appellate court. These appeals are usually dealt, in fact, dealt by the respective high courts under Section 11, because the first appeal usually goes to the district judge, and then from there, the second appeal lies before the high court. Now, this lot of sections specifically talks about the circumstances where your second appeal lies. There's a very specific set of circumstances on the basis, or very specific set of grounds on the basis of which you can raise a second appeal before a high court. What are those specific grounds? What are those specific circumstances when the court can entertain a second appeal? Are outlined in this specific lot of section. Section 100, for example, talks about that a second appeal can only lie before a high court in case there is a substantive question of law which has to be decided. There's a specific procedure which has to be followed by the high court. It has to, and there's a specific procedure which you as a lawyer, when you're drafting a second appeal, you have to follow, which has been outlined in this specific section. For example, when you're filing a second appeal, you need to clearly state in your pleadings that there is a substantial question of law which is involved in these proceedings, and this is the specific substantive question of law. Then the court will take up your second appeal. It will formulate in its own words that specific substantive question of law, and then it will move forward. And before it proceeds to hear the matter, mandatorily, the court will hear the opposite party regarding any objections that the opposite party might have regarding the court's formulation of this substantive question of law. Once these arguments are done, then the court will proceed to hear your second appeal. So, how and when these procedures are done and in what manner these proceedings proceed is what this set of sections deal with. Uh, of course, Section 102, there are certain cases where no second appeal lies. These are usually your cases wherein the suit value is less than 25,000. Now, an important thing to note in the context of second appeal is that Section 100A and 101 are sort of restricting the scope of Section 100. Already, the scope of Section 100 is very restrictive, that there has to be a substantive question of law. Section 100A and 101 further declares, very specifically declares, that in case there is any other ground except for that is mentioned in Section 100, you cannot be hearing a second appeal. So, by way of implication, Section 100 and the grounds mentioned in Section 100 are to be adhered to in a very, very prominent manner, no matter what. We'll discuss this in detail when we discuss with this topic. Okay. Moving on. Appeal from orders. Now, these are also sort of ancillary sections. For example, Section 104 talks about the orders from which appeal lies. It's a generic section. It has certain specific cases. For example, in the cases wherein proceedings have been initiated in Section 91, which we just talked about, public nuisance, and there has been certain orders which have been passed. Those orders can be appealed by way of Section 104. Any other orders which have to be appealed, and what are those circumstances which can be resorted to when an appeal has to be made, are dealt with Section 105. These are basically your arithmetical errors, your basic irregularities which have been mentioned in the appeal. So by way of those specific errors, an appeal can lie. Yeah. General provisions, of course, these are again ancillary provisions. what powers the court have when they are sitting in appellate jurisdiction. For example, section 107, the court can either frame issues and send it back to the trial court. The court can decide the matter itself. Finally, the court can remand it back. Things like that. What options do an appellate court has at its disposal while it is sitting in its appellate jurisdiction is what section 107 and 108 and 109 talks about. 109 is slightly different. 109 specifically talks about in what specific cases an appeal would lie to the Supreme Court. Again, a very restrictive section. Section also entails specific grounds, and on those specific grounds, only an appeal can lie before the Supreme Court. That being any specific substantive question of law which is of general importance, or in case the High Court is of opinion wherein the court feels and records by way of writing in its order that this specific issue should be decided by the Supreme Court. Only in that specific restricted circumstance can section 109 be resorted to. But again, a general provision. Now, this we have already covered. These are the orders which are linked to your sections 96, 98, 100, and other orders and other sections which deal with your appeals, in what cases you have the right to challenge, and what are the procedures to be followed, what is the procedure to be followed in case an appeal lies to the Supreme Court, what all documents, in what forms the documents have to be attached along with your appeal, and things like that. So basically a detailed procedure with regard to your appeals is given in these specific orders. Okay. Okay. Now reference, review, and revision. Okay, there's a slight correction. The section for reference is section 113. It's not 115. There's an inadvertent error. Section 113 basically talks about what you call a reference. Reference is something wherein a lower court, if it feels that there is certain thing which has to be referred to the High Court for certain clarification, it can be on law, it can be on any custom, it can be on any usage which has the force of law. Such specific circumstance which, in the opinion of a lower court, he feels that this is something which I should not be deciding, or which is something which is very important and should be decided by the High Court. Then under section 113, this lower court can refer this specific matter to the concerned High Court for its opinion. The High Court will record its opinion on that specific reference point and will send the matter back with their observations, and the lower court can proceed. Order 46, the procedures, in what form the reference has to be framed and things like that are mentioned. Section 114. 114 talks about the review procedure. Review is a procedure which can be resorted to in case there is an appeal, but you prefer not to go in your appellate jurisdiction, or in cases where there is no appeal, which can be preferred. Important thing to note is that the review jurisdiction lies with the same court which has passed the original order. So it goes before the same court. Again, it's a strategic decision whether you need to go in review or whether you need to go in appeal in case you are eligible for an appeal. You decide on the basis of facts and circumstances. You decide on the basis of many other things, which we'll talk about when we discuss the section, as to when do you prefer a review and as to when do you prefer an appeal. So the order and the section is what you see on your screens. Section 115, revision. Revision is a process which again goes to the higher court, again in certain specific scenarios. Usually these scenarios are mentioned in section 115. These are the scenarios wherein the lower court either has not exercised the jurisdiction which it should, or it has exceeded its jurisdiction, largely related to jurisdictions and things like that. Again, there is a clarification which is given under section 115 as to what are the powers and what are the cautions which the higher court should observe when it's dealing with a revision petition. and what are the things it needs to be careful of, what are the amendments or modifications the Higher Court can refer, and what it certainly cannot refer. That is what you call your revision, and the process is outlined in this specific section. Okay. Now, these are your miscellaneous set of sections which you resort to. Section 148, when you seek enlargement of time from the court. Let's say you're filing a written statement and you're not able to file it uh, within a specific period, then you seek time from the court. Then, of course, court grants you time, but there has to be a law under which the court will grant you time. That law is outlined under Section 148. Two important sections in this specific lot of sections are your sections 148A and section 151. 148A talks about caveat. Now, what do you understand by the word caveat is, let's say you are anticipating an application which could be filed by someone against you, or if you're anticipating a claim which can be raised by someone before a specific court against you. 148 grants you the power to file what you call a caveat petition before that court and serve that caveat petition to the opposite party. If you file this caveat petition, then in case the opposite party eventually files a claim against you, and let's say you're not served with an advance copy, or the opposite party intentionally, deliberately does not serve you an advance copy in order to maybe get some ex parte stay or things like that, in that specific case, your caveat petition will come to your rescue. If you have filed a caveat procedure, and if you have filed and if you have complied with the procedure which is mentioned in section 148A, and you have served this caveat petition to the opposite party which you uh, suspect to file a claim before the court against you, in that specific circumstance, the court is bound before it proceeds with that application or with that petition to mandatorily serve you with that specific application, record your appearance, and then only the court will proceed. So it's a very, very important and very strategic thing, a petition, which we would be learning about. The second important section in this lot of sections is section 151. 151 may be one of the most important sections, which talks about the inherent powers of the court. Now, what are these inherent powers? What circumstances these inherent powers are used is what we will deal with when we deal with the section. Now, an interesting thing to note is that the section is phrased uh, in the manner that saving of inherent powers of the court. Now, why this section is specifically phrased in this manner, why the section does not simply read section 151 inherent powers of the court, it has a reason. The reason is that these powers are called inherent powers for a specific reason. The jurisprudence says that these powers are not the powers which the CPC gives to the court. These are the powers which exist with the court, are inherently there with the court by a matter of their existence. So you do not need any code, you do not need any other law or statute to give these inherent powers to the court, because these powers existed with the court from the very moment when this court was established. That is why you say saving of the inherent powers. The inherent powers which already exist with the court by way of its existence are saved by this section 151. In what circumstances these powers can be resorted to? What are the cautions, of course, which the court should be conscious about when they are resorting to 151 jurisdiction? What are the important judgments? How the jurisprudence has developed is what we'll deal with when we'll deal with the requisite section. Okay, 152, 153, very general sections in case there are some arithmetic errors in there, in case there are some clerical errors, then the court have the power to amend their judgments. 153 says there is also a general power to amend these judgments, of course, in such specific circumstances. What are those circumstances? We'll deal with details. Okay. Now, these specific orders we have already dealt with when we were dealing about the plaint, your form of pleadings, the form of plaints, your form of written statement, set off, and counterclaim. Again, written statement is, as you all know, is the reply which the defendant could file to your plaint. Now, in what format that written statement has to be filed, what documents have to be affixed, in what manner these documents have to be affixed, what is a set off, in what manner a counterclaim, in case a defendant has to raise a counterclaim, has to be drafted and brought before the court, is what this order tells you about. Again, a procedural order to clarify how and when and in what manner you file your written statements and raise your counterclaims. Okay. Uh, these specific orders, again, procedural orders, deal with the appearance of parties, in what manner, when the parties have to appear, what is the procedure the court has to follow when it has to summon a party, that the party has to appear on a specific day on which the court have summoned, what are the powers in case both the parties default in appearing, what is the procedure to be followed in case only one specific party appears, where the defendant appears, things like that. These are the powers which are outlined under Order 9 of your Schedule 1. Order 10 deals about in what manner the examination of parties are to be conducted, in what format that examination has to be recorded, in what format and before which authority that examination is to be conducted. For example, in Delhi High Court, in its original jurisdiction, if there is an examination of the parties, if there is a chief examination or a cross examination to be carried out, it is not carried out before the judge. It is carried out before the judicial registrar in the court of a judicial GR, judicial registrar. So these specific nuances are governed by Order 10. Okay. Then again, the orders, ancillary orders, in cases there are settlement of issues, in what manner there can be settlement which can be assisted by the court, in case there can be certain issues that can be framed for settlement, how and what circumstances these issues can be framed, what materials that court can resort to while it's framing such issues, is what this order talks about. Now, CPC and how a civil matter proceeds is that when a suit is heard by a party, is heard by a court, uh, the first thing, of course, after determining the preliminary issues regarding jurisdiction, they frame certain specific issues which the court will eventually determine. How these issues to be framed, in what format these issues to be framed, and in what manner these issues are to be addressed by the court. Can these issues be amended? Can these issues be removed? Can a new issue can be added at a later stage by the court? These powers are governed by the orders that you just see on your screen. Uh, Now, Order 15. Order 15 is also a very interesting order, wherein the court has the power to dispose the case at the very first hearing itself. Now, in what circumstances this power can be resorted to, in what circumstances this power can be objected to by you all as lawyers, and what strategy is still different, but what are the nuances regarding the case wherein the case is held to be perfect for being disposed at the first day itself, is what your Order 15 and the requisite rules therein tells you. It talks about the circumstances, it talks about in what manner, in case there is a specific issue which can be determined or disposed of at the very first hearings, or things like that. Of course, we'll discuss the same in detail as and when we discuss the topic. Order 17, procedural order, deals with the adjournments, in what manner and under what circumstances adjournment may be granted, what remedies then court can resort to in case the parties are found to be deliberate in seeking adjournments. What if the parties fail to appear on a date which has been fixed by the court, things like that. Again, standard procedural order dealing with the adjournments. Now, these two specific orders are also can be considered orders dealing with certain specific and special circumstances wherein, let's say, a person against whom or by whom a suit is to be instituted is a minor. Then, in what capacity a minor can, under what capacity, and in what format, and through whom such minor can institute a suit is governed by Order 32. Similarly, if there is a person who is disabled, who is mentally disabled, who's of unsound mind, in what capacity and in what specific circumstance and through whom this person can raise a cause before the court is outlined in Order 30. Order 33 talks about your indigent persons, someone who cannot afford litigation, someone who cannot afford paying of court fee, someone who cannot afford maybe to raise a cause on account of him being indigent. Then what aid can the court offer, or what aid can the Code of Civil Procedure order to this person is outlined in Order 33. So I'm just giving you a brief. I'm just slightly touching upon these topics so that you all know that what all number one topics we all will be discussing and covering in the future sessions. And in case there is something, or if there is something specific which you all feel that should be discussed, then we can take up that issue. Then I think this is the last slide against, again, procedural orders regarding arrest and attachment. Let's say there is an anticipation that this person might evade the process of justice. Then in what cases a person can be arrested, in what cases a person can be asked to furnish a security in the matter, in the manner of a property to be attached, and things like that. Order 39 is actually a very important order. Order 39 deals with what you call temporary injunctions and interlocutory orders. Temporary injunctions, Order 39, Rule 1 and 2, are basically what you call stay orders in your common parlance. In what circumstances these temporary injunctions can be issued, in what circumstances these temporary injunctions should not be issued, in what specific circumstances these temporary injunctions can be issued ex parte, is what Order 39, Rule 1 and 2 talks about. Uh, Temporary injunctions, as the section heading says, is temporary in nature. This is basically an interim relief which you seek when you're filing a suit. So temporary relief, temporary injunctions, of course, are sought by filing a different application under Order 39, Rule 1 and 2 with your main suit. This application is decided at the first instance when the summons are issued and both the parties are present. Arguments are addressed on this specific application of yours. Courts pass an order regarding this temporary injunctions, whether an interim injunction should be given or not. And then the court moves on to proceed with the main matter. A very important tool which we as lawyers use, and very effective one also, because most of the civil cases, especially those civil cases which deal with the properties, are the ones wherein there is a very clear threat of the property being changing hands. So in those cases, it's very important. And as you all know, when a case is instituted, especially in the Indian courts, with the amount of pendency that we have, there might be a tendency for the court case to go on till for years. So you cannot be letting that property, which is the subject matter of that suit, to either change hands or to be sold off, etc. So in those specific circumstances, your temporary injunctions becomes a very important tool. Now, how to use it, utilize, how to draft your temporary injunction applications is what we will discuss when we'll take up this issue. Okay, I think this covers the brief overview of what civil procedure code has to offer, and what things, what sections, what topics we would be discussing in the future sessions. Okay, I think that would be all.